Thank you, everybody. So we are ready to start the last leg of today's conference. And for this purpose, I leave the stage to my colleague, Chiara De Cristofaro.
Thank you very much, Emanuele. Good afternoon, everybody. I hope you all find your seat because this part of the conference is about to begin. So good afternoon again, everyone. And I'm very thrilled and honored to represent the Young Bar of Rome for this beautiful initiative. And I want to say thank you to everyone that have made this beautiful initiative possible. And I don't want to take any time to our speakers of today. So I left the floor to the first one.
Thank you very much. I hope everybody can hear. Dear colleagues, a very good afternoon, everyone. And thank you very much for the opportunity to speak to you at this incredible venue in Rome. I'm very honored that you invited me for your conference. I would like to provide you with an overview of the judgment of the European Court of Justice from December 2024 on third-party ownership in law firms, probably known to most of you as the so-called Halma case. The second slide, please. I'm sure many of you are familiar with the decision, as it has not only been widely discussed within Europe, but several member states have also commented on the procedure in writing and at the oral hearing before the European Court of Justice. Nevertheless, let me give you a brief background to the underlying case, as well as an overview of the decision. Next, please. In 2020, the law firm Halma Rechtsanwälte, in the legal form of an entrepreneurial company, was established with a share capital of certainly just 100 euros. The Halma company was then admitted as such to and by my bar, the Munich bar, and thus allowed to provide legal services. Only a few months later, Halma Rechtsanwälte renamed in Halma Rechtsanwaltsgesellschaft, from lawyers to lawyers company, and 51% of the shares were transferred to a limited liability company under Austrian law named Sieve Beratung und Beteiligung GmbH. And this company is neither permitted to provide legal advice in Germany nor in Austria. The Articles of Association of Halma Rechtsanwaltsgesellschaft were amended to supposedly ensure the independence of the lawyers, inter alia to the effect that the shareholders meeting, or other managing directors may not exert any influence on the managing directors who are lawyers. Because of this transfer of shares to a legal entity not allowed to provide legal services under German law, we, the Munich bar, revoked the admission. The revocation, of course, was followed by an action against the bar by Halma, bringing it to the competent German specialized court for lawyers' conduct, the Higher Bavarian Lawyers' Court. This Higher Bavarian Lawyers' Court had and still has to rule on the revocation of the license to provide legal services due to the transfer of shares. During the original oral arguments, Halma claimed an infringement of the European freedom of establishment and free movement of capital. Because it was out of the scope for the German court to rule on the compatibility of national provisions of the Federal Lawyers' Code with EU law, the Higher Bavarian Lawyers' Court submitted in total 4 questions to the European Court of Justice in April 2023 for a preliminary ruling. Next slide, please. Now let me briefly introduce to you what the questions were mainly about. And I will preface that they mostly concerned the former German provisions of the Federal Lawyers' Code, not our current legal situation. The first of the Bavarian court's questions revolved around a possibly unlawful restriction to the free movement of capital, the potential infringement due to a transfer of shares to a person or legal entity that does not comply with the professional requirements of the national law. Under the former German provisions, only lawyers and specifically enumerated other professionals were allowed to hold shares to a company admitted to provide legal services. Although the list of other potential professionals contained quite a number of professions, it did not include all of the so-called liberal professions. This is the point, by the way, where the Advocate General later saw the incoherence in our system. Next slide, please. The second sub-question concerned the withdrawal of the admission of the law firm when a partner does not satisfy the requirements, when a partner does satisfy the requirements under national law, but is not professionally active in the law firm. Next. The last sub-question asks if it is compatible with EU law to withdraw the admission of a law firm if the majority of voting rights are no longer held by lawyers. And this brings us to the question where Halma made a lot of effort to make his point, whether a company's articles of associations can protect the independence of the legal profession adequately and sufficiently. Just for the full picture, the third and fourth questions address the compatibility with the Directive on Freedom of Services and the Freedom of Establishment, just to make this clear. So we should come to slide 8. So, how did the decision of the European Court of Justice look like in detail? Well, partly in line with the Advocate General, the European Court of Justice ruled that the free movement of capital, the freedom of establishment, and the freedom to provide services were infringed by the former provisions of the German Lawyers' Code indeed. However, the infringement is justified by overriding reason relating to public interest. The European Court of Justice named compliance with the principle of transparency and the lawyer's duty of confidentiality as those public interests interlinked to the rule of law in a democratic society. And in contrast to the Advocate General, the ECJ judgment declares unambiguously that the German provisions do meet the proportionality test. A general ban on third-party ownership of law firms to protect the named public interests is necessary and in proportion to ensure the independence and integrity of the legal profession as an essential part of the sound administration of justice and thus the rule of law. By this, the court emphasized the high value of the independence of lawyers in general. Quote, lawyers are assigned the fundamental role in a democratic society. Next, please. Equally important, the ECJ has made it clear that it is simply unrealistic to assume that a mere investor has not at least indirect influence over the law firm. Again, let me quote. The desire of a purely financial investor to make a return on his or her investment could have an impact on the organization and activity of a law firm. Accordingly, if such an investor were to consider that the return on his or her investment was insufficient, that investor might be tempted to demand that the firm reduce costs or seek a certain type of client if he was not to withdraw his investment. Such a threat is sufficient to establish that a purely financial investor has the ability to exert influence, even if only indirectly. To make it short, inadequate influence on the lawyer could be exercised by the investor simply by threatening to withdraw his capital from the law firm. And this is where the ECJ clearly distinguishes the lawyer from a pure investor. Of course, the lawyer has economic interests as well, but he is also subject to the professional's laws and ethics. In that regard, the Halma decision of the ECJ builds on top and continues a line of case law that carved out and strengthened the paramount role of lawyers in a democratic society. Just to name a few. Already in 1982, the European Court of Justice in the AMNS versus Commission ruled on the position and status of a lawyer. This decision was picked up in the renowned Akzo Nobel judgment from 2010. Again, a quote. The requirement as to the position and status as an independent lawyer is based on a conception of the lawyer's role as collaborating in the administration of justice by the courts and as being required to provide in full independence and in the overriding interests of that cause such legal assistance as the client needs. And also the European Court of Human Rights had already underlined the fundamental role of lawyers in a democratic society to represent the parties. The court pointed out that this role cannot be fulfilled without the all-encompassing protection of the confidentiality between a lawyer and their client. With the latest series of judgments on this matter, the ECJ reinforced and refined the position of lawyers. The fundamental task entrusted to them, according to the court, is recognized in all member states and plays a crucial role in upholding the rule of law. Lawyers are assigned a fundamental role in a democratic society, that of defending litigants. Any person must be able, without constraint, to consult a lawyer whose profession encompasses, by its very nature, the giving of independent legal advice to all of those in need of it. In light of this, the European Court of Justice's ruling is not particularly surprising, even in view of the opinion of the Advocate General. Although he considered our former legal situation to be incoherent, he emphasized that the ban on third-party ownership is suitable for achieving the stated objectives of the proper administration of justice. So what's next? Let me take you at this point to a more practical approach and perspective on the whole topic, since even though the European Court of Justice has decided, our discussion on national level is kept alive by some players, by the same players, of course, and the case is still not closed yet. The most interesting question seems to be, who are those potential and interested investors who shall shower the law firms with their money? For private equity investors, this picture is certainly unrealistic. The legal advice product is not scalable enough and therefore not profitable enough. Opening up the shareholder structure to third parties would instead attract the attention of legal expense insurers. Oh, just one back, thank you. Legal expenses insurers in Germany have been pursuing the goal of changing the legal market for quite a time. This includes 3 demands in particular. First, legal expenses insurers want to negotiate directly with their policyholder's opponent. Therefore, they want to engage in active claims management. Secondly, legal expenses insurers want a major client discount from lawyers. However, according to our Lawyers Act, lawyers are not allowed to agree to lower fees than those provided by our Federal Remuneration Act. And last but not least, legal expenses insurers wish to be able to offer legal service and insurance service from a single source. I guess I don't need to explain to you that insurers and clients don't always have the same interests, and therefore we at the Munich Bar and at the Federal Bar don't welcome that approach. Next, please. And so, with regard to the Halmer case, the German Federal Ministry of Justice just conducted a survey on the legal profession to obtain their own opinion on the matter. And while only 7% of the lawyers viewed a loosened ban on third-party ownership as necessary, and only 6% saw it as a chance, a vast majority of 63% were against easing or abolishing the ban. Next, please. Consequently, almost 80% of the lawyers who participated in the survey do not want purely financial investors involved in their law firms. And in line with the European Court of Justice's judgment, the majority, 73%, thought that the threat to the core values of the legal profession by purely financial investors is not manageable through any form of regulation. As I mentioned before, legal expense insurers, who have long been pushing for the right to provide legal services themselves, have a considerable interest in acquiring shares in law firms and shaping them according to their own ideas. They and other potential investors may not like the European Court of Justice's ruling. I think it is right in every aspect. There were some objections raised by critics that the ruling was concerned with the old version of the German Federal Lawyers Act, did not consider the fact that all liberal professions are now entitled to form partnerships. But that's not convincing. There's nothing in the European Court of Justice's ruling to justify a different assessment, especially since it quotes extensively the new situation and therefore has it thoroughly in mind. Nor does the critics' objection that the ECJ did not address the question of coherence in German professional regulations catch on. This question was, after all, intensively discussed in the proceedings. The Advocate General examined the question of coherence, which he actually negated, in detail in the context of proportionality. And the European Court of Justice has truly dealt with this in great detail for its circumstances. Consequently, the European Court of Justice has always had the question of coherence in mind. So, the Grand Chamber of the European Court of Justice has spoken out in favor of the legal profession against third-party ownership of law firms, and that is a good thing for all of us. I hope to have given you a little insight over the case, and thank you very much for your attention.
Thank you very much for the beautiful intervention and the perfect timing, as you assure me. So now I give the floor to the second speaker of this afternoon, Alessandro Renna. The floor is yours.
Thank you very much. Good afternoon, and thank you for the invitation from AIGA and the Bar Association of Rome, Milan, and Turin. Thanks also to the sponsors and partners of this wonderful conference. I was a lawyer for 11 years, and for the past 11 years, I have been an entrepreneur in the field of digital transformation and technology. Over the last 2 years, I've focused on artificial intelligence, developing software solutions and training programs. That's why my talk today is about the AI in the legal industry. It is particularly significant to me to discuss this topic here at the Supreme Court, the key institution for the Italian lawyers when it comes to protecting rights. In fact, I believe that dealing with AI in the legal sectors means for lawyers exactly to demonstrate the very skills and competencies that define their constitutional role in defending rights. Let's start with some context on generative AI, the most relevant type of AI for our field. This will help us to reflect on key priorities and navigate the extraordinary revolution which is happening before our eyes. Generative AI is the fastest growing technology in the human history. Launched in November 2022 by OpenAI with ChatGPT, it's now used by billions of people worldwide. The market is expected to reach $245 billion this year and grow at an annual rate of 28% over the next 5 years. That means that this market will reach $827 billion by 2030. The rapid adoption happened essentially for 3 reasons. First of all, this technology is accessible to anyone requiring no technical skills, as it works with natural language. Second, it is available to some extent also for free. Third, the fact that it is useful is immediately clear by using it, which is different from the case of blockchain or virtual reality, which tend to have hype cycles. Let's focus on these factors, the usefulness in the legal industry. Those who have used the AI know that it can instantly perform many typical legal tasks with high quality. Some examples: summarizing documents, analyzing documents, drafting legal texts, answering legal questions. AI can produce extraordinary results in these areas, but the quality depends on different factors. First, the quality of the AI system used. Second, the quality of the data made available to the AI. And third, the quality of the prompts, which is the way we ask to the AI to perform a task. Because of these 3 variables, opinions on AI range from enthusiasm to skepticism. However, in the best case, I can confirm unbeatable results in terms of time saving. Those who use AI in a structured way save between 60% and 90% of their time compared to those who do not do it in the above-mentioned cases. However, and that's strange to me, many lawyers still haven't actually tried AI, and I believe this might be really dangerous today. This brings to a couple of reflections. The first key consideration for me refers to the widespread concerning among lawyers about AI. There is often a misplaced fear that AI will replace lawyers. In reality, AI does not replace humans, but performs a certain tasks faster and with fewer errors than the humans. However, it always requires human input and oversight. After all, AI is just a tool, an extraordinary one, but still a tool. This is the human-in-the-loop principle. The issue is only for those who do not know and are not able to use AI. Rather than worrying, lawyers should focus on learning how to use AI and understanding what new skills they will need. There is a growing fear of being obsolete today, but the only solution is to study and apply AI in practice. On this point, I'd like to mention the first Charter of Principles for the use of AI in lawyers' activity from the Milan Bar Association, led by President Antolino Lalumia, which was here today. This document highlights the need for legal professionals to acquire AI-related skills and introduces a new meaning of the traditional duty of competence provided by the Code of Conduct for lawyers. When AI becomes a normal work tool for lawyers, the duty of competence will have to widen and include knowledge of AI. The second key consideration I'd like to share is about the responsibility of lawyers towards the market. Using AI in the legal work means sharing data with AI systems. This includes confidential and personal client information. Lawyers have a duty to protect this information, making them accountable and treating them according to rules and best practice principles. This requires cybersecurity of the AI systems, strong data policies, transparency with clients about AI usage, and today we work with several public and private companies. We see that clients expect law firms to ensure security and compliance with the rules because the law firms deal with the rules. Again, these principles are well outlined in the Milan Bar's Charter of Principles, which I believe is a fundamental starting point. From these reflections, I see a couple of priorities for the legal industry. I would say in a few words that a structured approach to AI is crucial. First keyword I would highlight is education. We are at the very beginning of the AI revolution. Lawyers must stay informed and updated on developments, which will be rapid in the coming months. One example is the agentic AI, the AI that can act autonomously, for example, gathering client needs, analyzing them, and preparing reports and even voice messages. This is not science fiction. This is almost ready today. Lawyers need to lead this change and seize new professionals' opportunities, and this comes through education. Second keyword for me is the concept of secure AI systems. We need to focus in the legal industry on the adoption of secure AI systems, strong data policies, and market transparency. The legal sector will define its AI future based on trust and reputation. Law firms that demonstrate skills and reliability on AI adoption will have a competitive advantage. Given the new skills and the organizational challenges brought by the artificial intelligence and in general by the technology, it is not unrealistic to imagine law firms evolving progressively into legal tech companies, hiring engineers, and proposing legal tech services instead of just legal services. Some firms are already doing this. If this trend continues, law firm aggregations will become even more relevant as critical mass is needed to support investments and expertise. Once again, IGA has been ahead of its time in recognizing this. In conclusion, I think that AI requires a wide mindset and a structured approach from lawyers. We must avoid two extremes: ignorance and underestimation on one side, and the illusion of easy, ready-made solutions on the other. There are no shortcuts in the legal profession. If we want to protect the prestige of our profession and lead it into the future, we must rely on the core qualities that define a true lawyer and are the foundation of the rights protection I mentioned at the beginning of my speech: method, depth, and transparency. Thank you very much.
Thank you very much for your intervention, and even to you for your perfect timing. Now I, in conclusion, want to call on the floor the president of the ABA, Ms. Shannon Gowley, in order to have a conclusion speech.
Dear colleagues, friends, and distinguished guests, I appreciate it has been a long day, so you will be happy that my closing remarks will be quite brief. I hope you have enjoyed the educational part of this year's EYBA Spring Conference. I think we can all agree that the diverse range of legal topics and the quality of speakers has been truly outstanding. One phrase that stood out for me today was something that Julia said this morning, and that was, the future of law lies not in statute, but in the choices that we make. And I think that captures the essence of the EYBA and our spring conference. Each of us made the choice to take part in this conference, to step outside our daily routines, and to engage with new ideas and connect with fellow legal professionals from across Europe. And that choice in itself is a commitment to shaping the future of law. And so today, as we explored contemporary legal challenges to the European landscape, we heard about some of the most pressing issues that are affecting our profession. From the legal implications of the environmental strikes to the evolving Italian Code of Ethics, the ban on third-party ownership of law firms, AI, neuro rights, and many, many more. It is these issues that shape the work of young lawyers and the legal systems that we uphold. None of these discussions would have been possible without our exceptional speakers. Their expertise, insights, and generosity in sharing their knowledge has been invaluable, providing us with fresh perspectives and challenges to see beyond our own jurisdictions and legal traditions. And so on behalf of the EYBA, I want to extend my sincere gratitude to each and every one of our speakers for their time, their dedication, and contributions to this conference. And please join with me in showing your appreciation. Thank you also to the Bar Council for allowing us to host our conference in such a historic and prestigious venue. And of course, thank you to our organisers for their tireless work and efforts in putting together such a stellar educational programme. Thank you also. So that concludes the educational part of our spring conference, but it is far from over. We do invite you to do as the Romans do and to join us this evening for our Roman dinner, which is taking place at 7:30, to indulge in full Roman cuisine. So all I can say is bring your appetite and we will see you there. Thank you, everybody.
Thank you very much. Thank you for representing this beautiful association all over Europe. And now, good afternoon, everyone. Enjoy Rome. Thank you.